Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Luqmanulhakim bin Mahzan. My metric number is 1201494. Today I will talk about case review in the case of Mastunah binti Haji Hassan v Haji Abdul Rahman bin Haji Hassan and others. First of all, fact of the case. Facts of the case: in this case, the Sharia High Court dismissed the appeal from the appellant Mastunah binti Haji Hassan, who appealed this case to the Sharia Court of Appeal, in which she was dissatisfied with the trial judge decision and tried to replace the deceased plaintiff who filed the claim for matrimonial property arising from the late estate of the late husband by the late plaintiff regarding the adjourned matters at the trial court of the first plaintiff, which is her mother due to the decease of the plaintiff. Parties involved in this case is Mastunah is the daughter of her mother, who also the plaintiff in the trial judge before, who was Dayang Hajarus binti Apong. Meanwhile, Haji Abdul Rahman bin Haji Hassan is the party who was being claimed. Next, issue involved in the case. Issue in this case is whether the second defendant or the appellant at the trial court could change her status and become the appellant on behalf of the plaintiff who passed away and appoint her own lawyer without the court's leave. Secondly, whether the Sharia lawyer could represent two conflicting parties. Next, whether the 6, 7 and 8 respondent who dropped the right to claim on the matrimonial property could be a respondent in this appeal. Lastly, whether the matrimonial property claimed by the plaintiff could form a distributable estate under Fara'id. My next point is argument by the parties. Because the trial judge in the trial court decided to stop the matrimonial property claim made by her mother because her mother has passed away, the appellant, Mrs. Mastunah binti Haji Hassan, was dissatisfied. The appellant cannot change status by standing in for the plaintiff. The trial judge further ruled, in order for the issues to be resolved, the appellant, who is not happy with the verdict, filed this appeal. The 6, 7 and 8 respondents request that the alleged marital property be utilized as an inheritance and divided in accordance with Fara'id law. However, the court denied their request even though with agreement of the appellant. This is due to the fact that the 3rd, 4th and 5th respondents are unsure of their opinions, rendering the agreement of all contesting parties unreliable and insufficient. My next point is court decision. Court held that claim for matrimonial property in this case, the person with the legal right was the plaintiff, but the plaintiff passed away during trial. Secondly, the appellant's lawyer did not file a notice to recuse himself from representing his client, the 3rd, 4th and 5th respondent, and this was acknowledged by the appellant's lawyer. This could cause a conflict of interest between the parties represented. Then, the 6, 7 and 8 respondents were still made respondents to this appeal, even though they dropped their rights against the claim for matrimonial property due to the appellant's negligence of misdirection. This issue was not diligently investigated by the appellant and her lawyer, and those respondents should not have been made respondents in this appeal. Lastly, court held that the court could not accept the application of the 6, 7 and 8 respondent to cause the matrimonial property claim as an estate under Fara'id, even though this was agreed by the appellant, because the consent of the conflicting parties were required. Last point is commentary. I agree with the Sharia High Court's ruling, which dismissed the appellant's appeal and affirmed the judge's order based on Sharia law and legal rules. I also concur with the Sharia High Court's ruling that the second defendant, Dayang Mastunah binti Haji Hassan succeeded to the plaintiff's position in this case despite the fact that the first plaintiff has passed away by changing his status. Regarding the second matter, I also agree with the Sharia High Court's ruling that Shari'i solicitors cannot represent both sides. This is to prevent from the occurrence of an intrigue conflict. According to the law of Chapter 39 of the Sharia Court's Property Proceedings Order 2005, a Sharia lawyer representing a party who wishes to be released must file a notice of withdrawal and provide a copy of the notice to the parties involved in the proceedings. In this instance, the appellant's attorney neglected to submit a withdrawal notice on behalf of his third, fourth, and fifth clients. Shari'i lawyers are aware of this and believe it to be a potentially contentious issue. In my opinion, this case should be brought to the sulus process to reach a consensus for all parties involved. The conciliation process can also help the parties involved with low costs resolve issues in a short time without having to take the case to the Sharia High Court, and the sulus process is very suitable for resolving their issues. That's all from me. Thank you.